Ladies and gentlemen, welcome aboard the Wright Flyer. I'm Randy Wright, and I'll be your captain on today's solo flight special edition of our state-of-the-art radio program. This is the final boarding call, and I cordially invite you to please claim your seats, fasten your seatbelts, kick back, relax, and enjoy the show while I go ahead and delve into the pre-flight checklist, because there really is a lot of news and information to get to before I may fully indulge you with your in-flight entertainment. Well, folks, here's an interesting thing to note. The United States Supreme Court has agreed to hear a case revolving around President Obama's illegal immigration amnesty executive order. Now, there's some interesting developments with respect to this. This comes out of Politico by their contributor, John Gerstein, and it was written on January 16th of 2016. The title of it is, "The Supreme Court is to Rule on Obama's Immigration Orders." Gerstein then adds a little caveat under the bolded title, in which he states the justices also added a question on whether Obama's actions violated the constitutional provision that he take care that the laws be faithfully executed. Now, folks, what's so important about that is it comes straight out of Article 2, Section 3. As you are all aware, the United States Constitution divides the power of government into three separate branches of government. Article 1 defines and enumerates power to the legislature. Article 2 enumerates and defines power for the executive branch of government, or the enforcing branch, and Article 3 defines the judiciary branch. So, what our founding fathers were doing there is absolutely couched in the natural law tenets that underpin our entire shared Constitution. As you are aware, the natural law tenets that underpin our entire representative Republican form of government are rooted in the idea that absolute sovereignty rests squarely in the hands of we the people. That has been the structure of our government from the very beginning, and it shows the absolute sort of foresight that our founding fathers had with respect to the way that an open, honest, and fair government is to operate. And indeed, I believe this explains why our Constitution is the longest contiguous Constitution in all of world history. Now, I know that Jeremy and I have oft-times reiterated on past episodes of the Wright Flyer that the greatest service that we can render unto you, our cherished listening passengers and audience, is to provide you with the tools necessary to expand upon your fluent and working knowledge and understanding of our shared Constitution, and thereby our fundamental and unalienable rights. And this is part of the reason why. When you look at what the Supreme Court justices are adding to the questions as to what they're going to hear with respect to Barack Hussein Obama's illegal amnesty program, it doesn't absolutely give you an idea of how the court will ultimately rule on the issue, but it does give you some insight that at least enough of the justices are concerned with this undeniable pattern that we see with respect to the Obama regime with encroaching upon the powers of the co-equal branches of government. It is not something that can be ignored, and it is a very definite pattern that we have seen time and again ever since he first assumed the reins of political power in this country back in January of 2009. And what that ultimately means for all of us is that the president is acting in such a way as to raise alarm for the other branches of government. Because when you stop and think about the natural law tenets that underpin our Constitution, you must remember that we the people have delegated power and authority to the federal government, at least in two stages. The first stage was to delegate power to the governments of the several states pursuant to the shared constitutions of the various states. Then the states, in a representative capacity of the people, further delegated power or enumerated authority unto the federal government via our shared constitution. So, what it really comes down to is that the Constitution is a contract between the ultimate wielders of sovereignty, we the people, and the federal government. It dictates and mandates, as well as outlines, the specific powers, duties, and obligations of the federal government, and it explains what the relationship between the federal government, the states, and the people is supposed to be. And when you really break that down even further, it's very important to recall that it is only the people, the true wielders of absolute sovereignty and authority in this country, who possess rights. And that goes back to the conclusions that George Mason made when he was called upon to draft the Declaration of Rights for the state of Virginia, and then later became an integral part of including the Bill of Rights, or the first 10 amendments to the United States Constitution, into the Constitution as well. And what he concluded, and I know that this is basically a refresher here, but folks, it is of the utmost importance that I think it bears repeating here yet once again. And his conclusion was that we, the people, are endowed by our Creator with certain fundamental and unalienable rights, meaning that no legitimate, rightful, earthly authority without due process under the law can strip, abridge, belittle, or take away our fundamental and unalienable rights. And that is exactly why I believe the justices included that question into the works here. Now, I'm sure many of you are wondering what this has to do with the price of bat guano in Peru. Well, the reason that this is important is that it speaks to the hopes and aspirations of our founding fathers. After all, they had an inherent distrust of any centralized authority. If you recall, the long and drawn-out bloody affair that was the American War of Independence was absolutely a conflict between the centralized governmental authority of the British Crown and the notion of popular sovereignty. Our founding fathers absolutely wanted the Constitution to be the bedrock upon which an open society would be built. And that is why they included Article 6, Clause 2 within the four corners of our shared Constitution. Ultimately, the notion of popular sovereignty, which is a part of the natural law tenets that underpin our shared Constitution, states unequivocally that the American people are the ultimate wielders of sovereignty. Now, that may seem so lost and so out of place when you look at the way that the government acts today, but that is absolutely the way that our founding fathers had intended for the Constitution to work. And therefore, what we see with the Obama regime acting in a way via executive power that is abusive, to the point that it denies the American people their sovereignty, and that it encroaches upon the expressly enumerated legislative power to the legislative branch of government, what you see is an absolute disrespect and assault on the separations of power as it was intended by the Founding Fathers. Again, this was designed as a check and balance to protect the will and consent of the absolute sovereigns in this country. And, I pointed to this Breitbart piece by Pat Cadell back in December that stated that about 2 to 3/4 of the American population no longer feel that the government is ruling with their consent. Now, folks, the reason that's so important, and the reason that we need to give such credence and weight to that, is because when you stop and consider the way that our founding fathers had originally devised this system of government, it shows that the people feel that the government is no longer working within their best interests, that they no longer have the prerogatives, hopes, dreams, and aspirations of the American people at heart. And unfortunately, this is a problem that has been festering for at least a half-century. We have seen it since the time of World War II and before. Actually, we've seen this since the dark days of the American Civil War. But because of revisionist history, because of the graduates of Pavlov's School of Journalism for the salivating mainstream media, we see that the political powers that be are doing everything within their power to sweep this under the rug. They don't want the American people to consider this, or to know what the proper scope and application of government is. Yet, folks, it is right there in black and white, crystal clear, as bright as the day, as to how this government is supposed to run. And that is our Constitution. It's why Jeremy and I say that the most important service that we can render to you, our cherished listening passengers and audience, is to provide you with the tools to expand your fluent and working knowledge of our shared United States Constitution, and thereby your fundamental and unalienable rights. It allows you to see through a lot of the code words that are espoused by the graduates of Pavlov's School of Journalism for the salivating mainstream media to absolutely discover the truth, to see the wholehearted meaning of what's there. Take, for instance, the idea that the justices added the question of whether the Obama regime has abused their power and has violated Article 2, Section 3's impetus, stating that the president is to faithfully execute the laws of the land. Now, clearly, that is not the case, is what Obama has done. And this goes all the way back to when he initially assumed the reins of power back in January of 2009. I say this because of the way that he has utilized his executive order power. Now, stop and think about that for a minute, folks. What is an executive order? Well, an executive order is just supposed to tell the executive branches of government how to operate and how to carry out the will of Congress. What Obama has done with this so-called executive amnesty is to absolutely change the purpose, impetus, and meaning of a well-established law that had already been signed into law by a previous presidential administration. That is not the way that an executive order is supposed to work, and that is why many constitutional scholars, including left-wing constitutional scholars, have come out and said over the course of the Obama regime that he has created a constitutional crisis. And of course, the constitutional crisis that he has created is that he is amassing illicitly more and more power unto the executive branch at the expense of the legislative branch. He is using executive orders in a way to create a sort of fiat second legislature, which the Constitution does not provide for, and therefore he is actually acting in an illegitimate, rogue, and tyrannical fashion. Now, folks, this has been with us since he first took office, but he has accelerated it and has shown no signs whatsoever of backing down from his attempts to absolutely, arbitrarily take away our fundamental and unalienable rights. And that is dangerous. Now, what is it that the Supreme Court did? According to Josh Gerstein, the Supreme Court announced Tuesday, that would be today, that it will take up a case challenging the legality of President Barack Obama's executive actions aimed at granting quasi-legal status and work permits up to 5 million people who entered the U.S. illegally as children, or who have children who are American citizens. Now, folks, this is really big because it speaks to what the president has been doing that absolutely infringes upon the expressly enumerated powers of Congress. Then Gerstein continued that the High Court's widely expected move gives Obama a chance to revive a key legacy item that has been in limbo for nearly a year since a federal judge in the state of Texas issued an order halting immigration moves the president announced just after the 2014 midterm elections. So why is this so important? Well, it's important to recall that pursuant to Article 1, Section 8, that specific part of Article 1 that expressly enumerates the legislative authority and power of Congress, it's included within those enumerated powers that Congress and Congress alone shall make the immigration law determinations in this country. In particular, Article 1, Section 8, Clause 3 states that it is enumerated to the legislative branch to establish an uniform rule of naturalization and uniform laws on the subject of bankruptcies throughout the United States. But the naturalization part is the key part here. That states that Congress alone shall pass the immigration laws or draft the immigration laws of the United States. And the only thing that the president can do is sign off on that law, which a prior administration had already done. Now, another important part to this is at the very end of Article 1. And this is the necessary and proper clause. This is Article 1, Section 8, and I believe it's Clause 18, that says to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. So you see, once again, the rules fall to Congress to make these vital determinations. And so what the president is doing here is a violation of the separations of power. Now, folks, in generations past, this would have never been tolerated. This would have been seen as a gross power grab by the executive and in absolute violation of the crystal clear and concrete language contained within the four corners of our shared Constitution. It is a major problem that we have seen repeat itself time and again ever since President Obama first assumed the reins of political power as president back in January of 2009. Now, if it seems that I am harping on this issue, it is because it is that important. We do not want a fiat secondary legislature. We do not want the federal government acting in a way that goes outside the proper scope and application of the federal government, as is clearly outlined, defined, and indeed mandated by the clear and concise language contained within the four corners of the United States Constitution. Whenever the government operates in such a fashion, it is not operating in a legitimate fashion. It has become a mockery of itself. It has become an illegitimate, rogue, and tyrannical government, and that is the very thing that our founding fathers sought to prohibit when they included the separation of powers within the Constitution. That is why, once again, Article 1 defines the scope and power of legislature. Article 2 defines and outlines the scope and application of the executive branch of government, while Article 3 defines and outlines the scope of the judiciary. And what we see with this Obama regime is that repeatedly they have ignored this well-established fact and formation of the federal government and how the federal government is to act and operate. And that in and of itself is a major problem because it shows that the Obama regime is wholeheartedly ignoring the proper scope and application of the federal government as it is defined, outlined, and mandated by the clear and concise language of our shared Constitution. Now, folks, this is not something that can just easily be ignored. because it goes to the legitimacy of the entire federal government as a whole. What we see is that President Obama is illicitly massing power unto himself in a constitutionally impermissible manner, and that in and of itself is troubling, because it shows that if he doesn't follow that law, what other laws is he willing to break? And I believe that the answer to that question is quite simple, that he is just absolutely willing to break any and every law that he disagrees with. Everything about this president is focused upon, aimed at, gaining more power for himself, irrespective of the detrimental impact and harm that it might have on the federal government at large and on the community as a whole. And that, too, is unacceptable. And the reason I say that's unacceptable is because when you look at the way that our Constitution is drafted, and the intent that our founding fathers had, that is, the original intent, we know that the founding fathers never intended for the president to amass such power unto himself, because it also goes against the express will and intent of the ultimate wielders of sovereignty in this country, we the people. Now, if there is one thing that can be said about the Supreme Court, and indeed the entire federal judiciary here in the United States, it's that it moves at a very slow pace. That has always been the case with the judiciary. It's because what they are attempting to do is to address these serious and significant questions which may have drastic and sweeping implications and ramifications for the fundamental and unalienable right of the citizenry. Therefore, you don't want them to be willy-nilly about how they handle cases, nor do you want them to just rush into something. You want them to be thorough. You want them to ensure that they are taking as serious and as close of a look upon an issue as is possible. Now, in recent times, the way that the court has been ruling has been outside the scope and application of what they are supposed to do. Now, that's not really entirely recent. This goes back to the 1803 case of Marbury versus Madison, when Chief Justice John Marshall assumed the power of judicial review unto the court itself without actually being given such a power via the clear and concise language of the Constitution itself. And we see the types of dangers that leads to when you look at the way that the court handled the so-called Affordable Care Act, or what is colloquially known as Obamacare. We see that they split definitions in order to finesse the law into working. In other words, finding a way to get a square peg to fit into a round hole, and that in and of itself violated the fundamental and unalienable rights of the ultimate wielders of sovereignty of this country, we the citizens. Now, according to Gerstein, the justices are expected to hear arguments on the illegal alien issue in April and to hand down a ruling by the end of June. Now, folks, I don't want to get your hopes up with any of this, because as we all recall, the last session of the Supreme Court absolutely defied all belief. You had John Roberts, for the second time, redefining and redrafting the so-called Affordable Care Act in order to make it pass constitutional muster, and then he was lamenting about activism in the court when it came to the Obergefell decision, which was legalizing same-sex marriage in all 50 states. Of course, he was blinded to the fact that he was absolutely being an activist judge in the Affordable Care Act case. So, based on the past track record of the Supremes during this Obama regime, there really isn't much reason to hold out much hope that they will strictly adhere to the clear and concise language contained within our shared Constitution. But if you stop and think for a moment, folks, that is exactly what the Supreme Court is supposed to do. They are not supposed to turn to outside law or external law in order to make decisions. They are supposed to act clearly within the confines of the United States Constitution. And again, this ties into the fact that Article 6, Clause 2 of the Constitution states that that sacred document is the supreme law of the land. And so we see that they're trying to continue to have this veneer of legitimacy, but after what we have seen with this term, this prior term with the Supreme Court, and indeed prior terms before even that, there really is not much reason to hold out hope for the court acting in a legitimate fashion. But what this does say is, and I'm going off of Gerstein's words here, if the court rules in Obama's favor, his administration, or what I would call a regime, will have a relatively short 7-month window to try to roll out the expanded Deferred Action for Childhood, which is basically your DREAM Act type thing, Arrivals Program, and the new initiative called Deferred Action for Parents of Americans. While advocacy groups are eager to have illegal aliens apply for the programs, there are questions about how many will do so if they're debuted or expanded so close to the end of Obama's presidency. And what that speaks to is this idea that the next president, should it be a Ted Cruz, would absolutely work to overturn the illegal executive actions and orders passed by this Obama regime. Now, I know that many people are going to point the finger and say that Donald Trump says that he will fix this problem. The problem with Donald Trump is that he has been completely and wholly inconsistent on his record. You know, he used to say that Ted Cruz was a nice person. Now he says he's nasty. He said back in September that Ted Cruz was absolutely qualified to run as a natural citizen, a natural-born citizen of the United States. Now he's trying to make political hay out of the issue. You know, folks, Donald Trump is just not someone that I would trust on this issue. I wouldn't trust him as far as I could throw him. That and his hairpiece scares me. But that being said, I do believe that there is fear in the illegal alien community that if the political powers change in this 2016 election, which it very likely just might, that they would run into a major policy shift towards, the welcoming of illegal aliens with open arms. And I want them to have that fear. Because why is it that we should allow them to stay here? Why should they get preferential treatment? This selective enforcement of the law creates a dangerous precedent within the country, and I'm not so certain that that would be a good thing. In fact, I am dead certain that it would be a horrific thing to have happen here in the United States, because it would put us in a very precarious and dangerous position. When you don't enforce the laws that are on the book, you have chaos and anarchy reigning supreme, and that truly, wholeheartedly, absolutely is the very absolute last thing that we need to have happening here in the United States of America. Now, there is something that Josh Gerstein mentioned in his political piece that I do have to take issue with, and one of the things that he said was the calculation of whether to apply may depend in part on the state of the presidential race. Now, I've already mentioned that this speaks to the idea that these illegal aliens are wondering whether the application of their illegal status to be basically given pure amnesty would be overturned by the president. This really should have no say. I mean, I know that it does, and I said that it makes sense that it does, but if you really stop and think about it, the fact that they broke the law should be concrete and final. The immigration law of the United States is well established. It's part of the reason why I have such a problem every time that these opportunistic politicians get up in front of the cameras of the salivating mainstream media and attempt to say that, look, our immigration system's broken. You know, the only reason that the immigration system is allegedly broken is that these feckless, spineless weasels of a politician would sit there and refuse to enforce the laws that are on the book. I think that when you look at these cities that are so-called sanctuary cities, and you see these states that are bending over backwards to grant amnesty to illegal aliens in full violation of well-established precedents in law, that indicates that we are basically on the brink of chaos and anarchy here in the United States of America, and it should not be tolerated. We should be enforcing our laws, and I have to applaud the Texas district judge that sat there and said, look, we shouldn't be giving carte blanche to these illegal aliens. They broke the law coming into this country, and there should be ramifications and consequences arising therefrom. That speaks to the way that the equal protection of the laws applies, even if you're a non-citizen. You see, that's the other type of problem that we see with respect to these illegal aliens and the feckless, spineless politicians that make up the political powers that be. They want to include the full girth of our constitutional protections to non-citizens. But if you look at the opening lines of the preamble to our shared Constitution, it says, "We the people." That inherently means we, the citizens of the United States. And as citizens of the United States, and as Jeremy and I have oftentimes reiterated on past episodes of the Wright Flyer, is we the people are the ultimate wielders of sovereignty in this country. But the way that you see these politicians reacting, and the way that the graduates of Pavlov's School of Journalism for the salivating mainstream media are reacting, clearly demonstrates that they are not operating within the confines of the government, and they're certainly not acting out of benevolence for the American people. It would seem that the caste system in this country has been established now, that non-citizens who broke the law to get here are going to get preferential treatment by the elitist politicians. And this can also be seen in the way that Benedict Arnold Paul Ryan, the Speaker of the House, has, ever since he first set foot into the marbled halls of Congress as basically a clerk and assistant to higher-ups, has pushed for this idea of amnesty. It shows that his loyalties are not to his constituents or to the American people, but to outside interests. Groups like the Chamber of Commerce, which should now be more aptly called the Chamber of Commies. We really should not be acting against the best interests of the people, but that is what we see time and time again. And so we know that the regime has been implementing executive order after executive order to skirt around the well-established law of the country, which is in itself a violation of the clear and concise language contained within the four corners of our United States Constitution, and pursuant to Article 6, Clause 2, the Supremacy Clause, is an absolute violation of the supreme law of the land. What has happened in America today? Why is it that we want to selectively enforce the law, that we pick and choose which aspects of the law apply, and that is now somehow considered an allowable thing? That's not a breach of the law. That is totally baffling to me until you get down to the nitty-gritty of what it is these politicians actually want. And what these politicians are pushing for is the steady weakening of the true wielders of sovereignty of this country, we the people. And that in and of itself is a major problem. But again, you're not going to hear this from the likes of the salivating mainstream media. It goes against the propagandistic message that they wish to convey. It goes against this idea that it is somehow compassionate to allow some to break the law while punishing tax-paying American citizens, the law-abiding, red-blooded American citizens, if they ever even mistakenly step outside the boundaries of the tax code that is totally incomprehensible and a worthless mesh of gobbledygook. That is a true departure from law and order. And of course, this is part of that whole Cloward Priven principle that is, by its nature, designed to overwhelm the systems of government so that the people will crawl to the federal government on bended knee asking for more government control, for the government to resolve the problems. But the government created the problem in the first place. This is the disconnect from reality that we see time and again with these so-called politicians. They want to claim that they know what's best. These are the people trying to wrest control of our healthcare system to prevent American citizens from being able to exercise their fundamental and unalienable right to keep and bear firearms. These are the people that want to flood this country with so-called Syrian refugees. Yes, I have a major problem with that because it goes against both the spirit and letter of the law. But again, that has no meaning to these feckless, spineless, weasel politicians that would do anything to subvert the actual sovereignty of the popular citizens. Popular sovereignty is absolutely an integral bedrock part of our shared Constitution. And again, folks, this just once again stresses why it is of the utmost importance for us all to have a fluent and working knowledge and understanding when it comes to our shared Constitution and thereby our fundamental and unalienable rights. It allows us to separate the wheat from the chaff, to see what is good and what is bad. And clearly, this is a major issue that is presenting a major problem for the American people, because as you can see time and again, the American people are absolutely sick and tired of seeing their will as popular sovereigns, as the ultimate sovereigns in this country, being trampled and ignored time and again. We see it with Benedict Arnold Paul Ryan. We see it with El Jefe Jeff A. Bush getting up there and saying that it is an act of love to enter into this country illegally. And that's part of what is so laughable about what Jeb is doing with respect to his negative campaign ads, his political attack ads against Marxist Rubio. He's attacking him for his stance on immigration, but the funny thing is, Marxist Rubio and El Jefe, there's no way to distinguish their stance on so-called immigration reform because they absolutely adhere to the same policy. Their beliefs are indistinguishable because they are the same. There's no way around that. And of course they're going to try and obfuscate that fact to gain political points, but the truth of the matter is there is no distinguishing them because they are the same. Now, this entire brouhaha started in February out of Brownsville, Texas, where the U.S. District Court Judge Andrew Hennen issued an injunction barring the Department of Homeland Security from moving forward with the Deferred Action Thing, DAPA, and DACA programs. He suggested that Obama lacked the legal power to undertake such vast changes in the immigration landscape without congressional involvement. but the judge based his ruling on the narrower, more technical ground that the changes were never formally proposed as regulations and put through the public notice and comment process under federal law. In both instances, I believe that the judge was absolutely correct here. As previously stated, Article 1, Section 8, Clause 3 clearly enumerates that the legislative branch of government is the sole proprietor in making immigration law determinations. So, once again, we see that the Obama administration is trying to skirt around Congress. You know, it's the same type of thing that we've seen him say time and again, say with the notion of trying to infringe upon the fundamental and unalienable right of the citizens to keep and bear firearms. He tries to say that due to Congress's failure to act, he is forced to go through executive action, instead of implicitly realizing, and I think he's being purposefully obtuse here, folks, that when Congress refuses to act, that is the express will of the people. After all, it was the people that elected their congressmen and senators, and therefore it is the people who have spoken when Congress and the Senate refuses to act. And so, once again, it just baffles me that Obama still thinks that he's part of the legislative branch of government, but actually it doesn't really. It shows me that he wants to act in a rogue and tyrannical fashion, that he wants to adopt the powers of a potentate and a despot in order to further encroach upon the natural law tenets that underpin our entire representative Republican form of government. And, you know, it doesn't cross his mind that what he is doing is totally out of line. For him, it just doesn't matter. He will double down on any and every effort to move forward against the American people and sovereignties, and sovereigns rather, because that is what he believes is his prerogative. So we see that the Brownsville District Court judge made this determination in February. By November, again, remember folks that our court systems move at an eclectic and slow pace, but in November, the Fifth Circuit Court of Appeals refused to disturb Hannon's nationwide injunction. This was a 2-1 decision of a three-justice panel, which then even went further than the lower court's ruling, and they held that Obama's actions were totally unlawful. Later in November, we see that the Justice Department asked the Supreme Court justices to take up the case. So we see that it's not just Texas going alone on this issue. There are 26 states backing the lawsuit, and the court will take up and argue this case, or will hear arguments on this case, that Obama breached his duty to take care that the laws are enforced and that his actions amounted to a power grab that violated the Constitution's separation of powers more generally. Now, folks, this is what I alluded to at the start of the show. This is something that we have seen occur repeatedly throughout Obama's tenure as president. His regime doubles down on every effort to encroach upon the separations of power, to move against the American people, and this is being done in very much so an impermissible fashion. But again, the political powers that be just don't seem to care. Now, again, I don't like putting all of our eggs in the judiciary, because they have shown time and again during the tenure and reign of this regime that they won't necessarily stick to the confines of the supreme law of the land, which, as per Article 6, Clause 2, is the United States Constitution. It is something that we will have to overcome. And, of course, I don't know if this was because the president had some sort of dirt on the justices, whether it was Chief Justice John Roberts' foreign adoptions that may have been done in an illicit fashion that could come back and muddy his tenure as Chief Justice of the United States Supreme Court. However, I think it goes beyond that, because if you stop and remember, Justice Roberts declared that Justice Jackson was one of his favorite Supreme Court justices. Now, it's important to remember that it was Justice Jackson that penned the majority opinion of the Wickard v. Filburn Court. That was the court that took the Commerce Clause out of its traditional scope of application and attempted to say that a farmer who grew a certain portion of his wheat to feed his family actually encroaches upon commerce. So what we see is that in July of 1940, for that, there was an act called the Agricultural Adjustment Act, or the AAA. And actually that was passed in 1938. Filburn's 1941 allotment was established at 11.1 acres and a normal yield of 20.1 bushels of wheat per acre. Filburn was given notice of the allotment in July of 1940 before the fall planting of his 1941 crop of wheat, and again in July of 1941 before it was harvested. Despite these notices, Filburn planted 23 acres and harvested 239 bushels from his 11.9 acres of excess area. And the reason he did that was because you have to remember that the Great Depression was still in effect at the time, and he was wanting to save money and supply food for his family. Well, what we see from Justice Jackson's opinion here is that that violates interstate commerce. We've since seen the Commerce Clause rolled back a bit since that time, but it shows that Chief Justice John Roberts idolized a man who wanted to criminalize providing for your family. And so that might also explain a lot of the odd behavior that we've seen with respect to the Chief Justice of the Supreme Court when it comes to these types of decisions. Nevertheless, what these types of decisions show is that they are operating outside of the purview and application of the supreme law of the land. That is something that should not be allowed. And so it is for that reason that I pause with respect to the Supreme Court handing down a true decision that follows the purview of the Constitution, because this court is led by a man who idolizes a true activist judge. I mean, there is no way around the fact that what Jackson did was an impermissible power grab by the Supreme Court to give the federal government the absolute say-so to regulate what people could or could not grow on their own land. Now, that, too, goes against the notion of popular sovereignty. It raises serious and significant questions about the legality and the legitimacy of what that court had handed down. And so, again, that explains why I hesitate with this court. Because if we approach the illegal executive amnesty proposed by this regime, as it has been by the Department of Justice here and the Department of Homeland Security, it's truly troubling. And it's troubling because they're going to sit there and perhaps see that this is a legitimate power grab, just as Justice Jackson had legitimized the Agricultural Act, that AAA Act of 1938. What we see here are the governments of the several states, these 26 states that brought this suit, attempting to stand up for their constituents. That is the proper scope and application of the way that a local or state government should react. After all, when you look at the hierarchy that is established by the natural law tenets that underpin our shared constitution, that is what they are supposed to do. This is why it is said that the state governments are possessive of plenary or near absolute power. And that is what they're trying to do here. They're trying to stand up for the health and well-being of their constituents because, as you know, when you enter this country illegally, there really is no background check. There is no tracing of your medical history, and after we had that Ebola scare back towards the latter half of 2014, I can clearly understand why we would want to ensure that the borders are more secure. And then you have on top of that the added threat of terrorist-type attacks from nefarious organizations like the Islamic State or ISIS. And so you see, the Obama administration, which is not an administration at all, it's a regime, is trying to overload our immigration system in an impermissible fashion. And again, this all ties into that Cloward-Priven principle, which wants the people to turn to the government with open arms for a solution to a problem that government created. You see, that is the nefarious and dangerous aspect of Fabian socialism that the graduates of Pavlov's School of Journalism for the salivating mainstream media, the nameless, faceless, and ultimately unaccountable bureaucrats, and the various other utopian socialists don't want you to know about. They don't want you to think about it in that fashion. They try and argue this from a position of raw emotionalism as if that will somehow increase the legitimacy of the arguments that are being put forward for this type of action or activity. This is how they support it. But what these states are looking for is to state that if the Supreme Court does not take this case and to let the lower court ruling stand. We see that the Supreme Court's taking the case. However, the Texas State Attorney General, Ken Paxton, who is a bit of a divisive figure on his own because there are indictments against him that may or may not be real. It will be interesting to see how that plays out. Said that the High Court's move reflected the important roles of the three branches of government. And I'm going to tend to lean towards Attorney General Paxton's position here, because I think that there is enough of a history with this Supreme Court to see that they don't like it when the executive branch is attempting to do an impermissible power grab. But I also fully understand the positions that were argued that the lower court ruling should stand. Because when you stop and think about it, there is a lot of uncertainty when it comes with the Supreme Court, particularly the way that they have been ruling in this last several sessions, or in these last several sessions. But as Paxton said, in deciding to hear this case, the Supreme Court recognizes the importance of the separations of power. As federal courts have already ruled 3 times, there are limits to the president's authority, and those limits enacted by Congress were exceeded when the president unilaterally sought to grant lawful present to more than 4 million unauthorized aliens who are in this country unlawfully. He then continued, the court should affirm what President Obama said himself on more than 20 occasions, that he cannot unilaterally rewrite congressional laws and circumvent the people's representatives. Yet we see that time and again that has been the stalwart position of the Obama regime. If he cannot get his way, then he will find a way to force his perspective through, irrespective of the detrimental and deleterious impact and consequences that it has not only on the representative Republican form of government enjoyed by us all, but also on the sovereignty of the people. Again, folks, this is why it is of the utmost importance for us to have a fluent and working knowledge and understanding of our shared Constitution, and thereby our fundamental and unalienable rights. Because when you stop to think about the way that this president has illicitly amassed power unto himself at the expense of the popular sovereigns, that literally creates a constitutional crisis in this country. Now, of course, the jaded left-wingers, those Fabian socialists that wholeheartedly support Obama's attempt to completely fundamentally transform this country, are going to say that the Constitution is some quaint, antiquated document that is inapplicable some 200 years after its original drafting. But, again, when you recall that our Constitution is based on timeless natural law principles, it means that the scope and application of that sacred document are just as applicable today as they were 200 years ago, and will be just as applicable in 200 years from now, unless these Fabian socialists are successful in their desired fundamental transformation of the greatest country on the face of the planet. This should not be taken lightly, especially when you consider that our Constitution is the longest contiguous running Constitution in all of world history. It means that we here in the United States, through the brilliance of our founding fathers, have discovered the most stable, the most open and honest form of government out of any nation on earth. And we see that the states are scrambling to protect their power as this rogue, tyrannical, and illegitimate federal government is attempting to quash their power in direct and blatant violation of the supreme law of the land, which is, of course, our shared Constitution. So when you stop and think about the type of threat that is literally facing the United States Constitution and popular sovereignty in this country, it becomes breathtaking. The redoubled efforts of this Obama regime, because it shows that they don't care. They absolutely do not care about the fundamental foundations of this country. In fact, they loathe and despise it, and their past actions have proven this time and again. Again, it requires me to bring up that old adage that actions speak louder than words. Barack Hussein Obama's actions have stated that he holds our shared Constitution and the notion of popular sovereignty with the utmost of contempt. And that is problematic, because the president absolutely is supposed to adhere to the fundamental natural law tenets that underpin our shared Constitution. And, of course, it also brings up this laughable notion that the president is about being a constitutional scholar. Yes, folks, there is no denying that he knows the Constitution of the United States like the back of his hand, but he is doing so in a form of malice. He is malicious in his desires to strip and deprive the ultimate wielders of sovereignty, we the people, of our rightful and legitimate sovereignty. And so, while not all states agree with Texas's stance in this case, the attorneys general of 15 states and the District of Columbia filed a brief with the Supreme Court last month arguing that Obama acted within his legal authority. So again, folks, we see that there is what is known in legal parlance as a forum split. But the states that are doing this, and particularly the District of Columbia, which should have no say in this whatsoever, as it is just a federal territory, it goes to show that they are not standing up for their constituents. And I feel safe in saying that because when you actually weigh the gravity of the situation and the fact that the sovereignty of the United States of America is in question here, and on top of that, the way that the vast majority of the American electorate feels about this, it once again lends credence to that December article in Breitbart News where Pat Caddell said that 3/4 of the American population absolutely feel that this government is ruling without their consent. This is a constitutional crisis unlike any other in living memory. Now, we have seen constitutional crises like this in our illustrious history. We saw it with the war between the states, or as it's more colloquially known, the American Civil War. We've seen it rise again during Woodrow Wilson's attempt to force the League of Nations upon us. We saw it again with FDR, or Franklin Delano Roosevelt's push of the New Deal, and each and every time we saw the power of the federal government grow exponentially and in ways which are constitutionally impermissible. Folks, when we break away from the strict adherence to the Constitution, which is the supreme law of the land, that is when we see the country start to fall into the type of decay that we are seeing all around us. Now, I know that many people will sit there and say that the economy should hold utmost importance, that it holds exceeding importance with the American electorate. Yes, that's true. But what are the factors that actually contribute to this faltering, weak economy that we are suffering through right now? And the answer to that is all of this steady march away from strict adherence to the natural law tenets that underpin the Constitution and the Constitution itself. In other words, we see the government acting in a way as to spread anarchy and chaos within the borders of the United States itself. We see a government that uses the power that's enumerated to it to abuse the power that it has, to illicitly amass power unto itself at the great expense of the ultimate wielders of sovereignty, the popular sovereigns in this country, we the people. That in and of itself goes completely against the United States Constitution. It goes against the foundational vision that our founding fathers had when they devised this country over 2 centuries ago. And, you know, folks, I don't think that it is, in fact, I know it is not a good idea to depart from the fundamental tenets of this country, the longest contiguous running constitution in world history. Because we know that it has worked. It has been a solid bedrock of a free, representative Republican form of government, the likes of which this world has never known before nor since. And the fact that we steadily depart from it and detach ourselves from it and divorce ourselves from it raises significant questions about the viability of this country's future. Now, I'm not saying that to fearmonger. I'm saying this as an officer of the courts and as someone who absolutely loves and adores the history of this country and the magnificent accomplishments that we have achieved in 2 centuries. It had been unheard of for an upstart nation like the United States to accomplish what it did in such a short amount of time, just as it was a revolutionary notion that popular sovereignty should be a part of the country, and it is indeed an integral part of the societal fabric of the United States. Now, that has a history that predates the United States. It goes back to the Magna Carta under King John, back in the medieval period, and slowly evolved, but then took a spearhead when our founding fathers and the American colonies became the vanguard of freedom and liberty. It was a truly revolutionary approach to government, and the way that our founding fathers devised the Constitution, which is the supreme law of the land, was to ensure that that spirit could be handed down to posterity. You see, folks, what has happened is we are seeing that our way of life, our standard of living, our quality of life, and yes, the economy, it's all tied into that. That is the overarching application of the way that government is supposed to work. And we see that the government is violating that sacred trust, is in breach of the social compact or contract with the ultimate wielders of sovereignty, we the people. And this is why Jeremy and I do these shows for you. It's because we want to bring this to your attention. We want you to know that there are these types of attacks on our shared Constitution. And what we see is that with this, the Justice Department has once again declined to comment on Tuesday's action by the High Court, but also neither the lawsuit in this instance nor the injunction directly involve the first version of the DACA program for so-called dreamers, which Obama set up in 2012. You see, folks, that was 4 years ago. We're approaching 4 years ago, and these significant questions need answers. But Obama is doubling down on his impermissible power grabs in order to fundamentally transform the United States. And part of that fundamental transformation is to completely change the demographic makeup of what it is to be an American. No one is saying that they are opposed to the allowing of legal immigrants into this country. What we are opposed to is selectively enforcing the law, allowing those that break certain laws to receive some sort of preferential treatment because it is thought of as being unfair or the compassionate thing to do. Reason must overcome passion and compassion in this case if we are to maintain our legitimacy as a free, sovereign nation. And so we see that Obama's thing has given to work permits to about 788,000 people. This new one involves about 4 million people. That is a staggering amount of people in a period of 4 years. That is the type of switch that could drastically unhinge a country and change its destiny and operate against what is good and decent about a country. And, you know, if you look back to the annals of history, the way that the barbarian hordes had moved against Rome, that too raised significant questions about the viability of Rome, and in fact it ultimately toppled Rome. We cannot close our eyes to this. Yet that's exactly what the graduates of Pavlov's School of Journalism for the salivating mainstream media would want to have happen. And we just can't allow it. Now, with that said, it is time to begin our descent. I'm going to go ahead and send the flight attendant back for one last round of alcohol. As always, I'm your captain, Randy Wright, and I want to thank you for choosing to fly the Wright Flyer, and I invite you to leave comments, concerns, and posts either here on our YouTube page, our Facebook page, or our Google Plus page. I also invite you to join Jeremy and yours truly the next time we take off over the friendly airwaves, providing you with an indelible yet pure sense of enlightenment as we always do. Thank you again, ladies and gentlemen. Do take care. See you next time.